Hello viewers, welcome to the YouTube channel Lex Consilium Foundation, and I'm Major General Neelendra Kumar here in conversation with Mr. Sudhish Pai, the well-known author, legal historian, and a senior advocate practicing in Karnataka High Court, apart from other places where he appears. And before this, you have known him, you've heard him speaking about the giants, the legends in the legal domain. Today, Mr. Pai, I would be speaking to you and we would be discussing this matter, the order by the Supreme Court, where it took suo motu notice of NCERT, a book for class 8, issued recently as part of the new education policy. And this book had a chapter on role of Indian judiciary in our society for class 8 students as a course on social science. And this book, mainly the two aspects that it covered in that chapter relating to judiciary, it pointed out cases of corruption wherever they may arise, and it also talked about the huge backlog and pendency. Mention about the judiciary was not to the liking of many in the legal profession. It was criticized, and promptly the Council for Secondary Education, Board of Secondary Education, they withdrew the book the very next day. They expressed regret, and also whatever books had been sold, efforts were made to retrieve them and to remove it from online. However, Justice Suryakant, in a bench headed by Justice Joymala Bakshi and Vipul M. Pancholi, the three judges bench, they indicated their unhappiness, and later the Chief Justice is reported to have said that heads must roll. He wanted accountability fixed, and the Prime Minister also at a cabinet meeting is said to have inquired into who's monitoring the text. Now, as far as the former judges and the law practitioners are concerned, there have been varied responses. Just to illustrate, on one side, Justice Gawai has found no fault in this report, and there have been excerpts about the sayings of Justice S.P. Bharucha, one of the former Supreme Court judges, activist, lawyer, well known. Prashant Bhushan has come up with an article where he says that further action should be taken and we need to talk about judicial corruption. On the other hand, Justice N.V. Ramanna, who was one of the earlier Chief Justices, he says that this is not called for, not needed. And he also said, commenting on the remarks of Justice Bharucha, he has criticized it. We'll not go into it. We are aware. We have pointed out the matter. And Mr. Pai, how do you look at the matter?
Who is the last Chief Justice you mentioned? You were quoting the
Justice Gawai.
Gawai, yeah.
Yes. And before that, Ramana has spoken about, and there is a division bench judgment of 2010 by Markandeya Karju and Gyansudha Mishra. They spoke very critical about the corruption, and so did S.P. Bharucha, a former Chief Justice of India.
This is indeed a very sensitive subject, but I think we must look at it straight without any passion or prejudice.
Quite right.
The bottom line is that every institution in our constitutional democracy has to be transparent, amenable criticism, and should not be oversensitive to anything that may be said about any of us. It's no doubt true that the court as an institution is entitled to respect. In my very respectful submission, that would not mean that one can never say anything about an institution, including the judiciary, its personnel, its functioning, its drawbacks. And of course, they are there. I think if we say that all is well, then we are being oblivious to the truth. Satyameva Jayate is the national motto, as Nani Palkiwala always reminded us.
Yes.
Nothing can be higher than the truth. You can always have two opinions about certain things. Right-minded, reasonable thinking persons can hold different views, but that does not mean that you shut out one view. Now, coming to the particularities of this situation, I ask myself, what is it that has happened for anyone to be so disturbed? I feel absolutely nothing. The action or the reaction of the court and its order, I'm afraid, is an overreach, has gone too far, and perhaps strikes at the foundations of all that we hold sacred in India. A textbook, I have not seen the text, and unfortunately, it is now out of bounds with the court order. So we have to go by what it's withdrawn. So we can't even examine what was mentioned in it. But going by what is reported, the chapter spoke about the role of the judiciary. It also spoke about corruption in the judiciary. That's what we are told. That corruption in the judiciary is a fact and not a myth, I think stands established long before any one of us, if I may say so, long before any of the present judges were born on the bench. More than 35 years ago, Chief Justice Venkatramaya in 1989-90 spoke about deviant behavior and lack of probity amongst some judges. No one says that every judge is bad or corrupt. It's not that. But even a handful is bad enough for an institution like the judiciary. Justice Venkatramaya spoke that. Chief Justice Verma, maybe a few years later, again said that in an interview that even Supreme Court is not free of corruption. And he said that the rot has gone deep into the system. Chief Justice Barucha said 20% of the judges are corrupt. This is therefore, whatever be the dimensions of the corruption, whether it is a very small percentage, I do hope and would like to believe it is only that, or a larger proportion. The fact remains that corruption is not an absent thing. If a couple of weeks ago, in response to a starred question in Parliament, the Law Minister also responded saying that there were about 8,000 odd complaints, judges in the course of the last 10 years. Be that as it may, we are not on the number of complaints, we are not on the details of the corruption. Corruption is not absent, I think is beyond slightest shadow of doubt. And if that be so, I fail to understand is so wrong for that to be mentioned as a fact. Of course, I don't know the language in which it's said because, as I said, we have not seen the book and it is now out of work. What we gather from the order and the whatever is reported is that the book does not take note of the great work the judiciary and the Supreme Court has done. I do not know whether the book mentions that or not. There is no doubt that the Supreme Court has done great work. Its role has been laudable, but that by itself cannot justify anything to shut out criticism or mention of corruption, which is accepted as existent. The book only holds a mirror to ourselves. And I think not only that one should not frown upon it, but I would go to the extent of saying that one should welcome it. Not welcome it to celebrate, but welcome it to go into the matter, discourse and discuss and find ways and means to stem the rot. The other reason that we gather is that there is corruption in every walk, and the content of this book seems to highlight only the corruption in the judiciary. Yes, there's no that there is corruption.
If I may interrupt,
Please.
I have here the Indian Express report. Now,
Yes.
if this report is to be believed, and I have no reason to think otherwise, it says the book Exploring Society, India and Beyond, Part 2 was released on Monday. A day later, Indian Express reported that chapter on the role of judiciary in our society featured a section on challenges faced by the judicial system, listing corruption and massive backlog on account of multiple reasons, such as a lack of the adequate number of judges, complicated legal procedures, and poor infrastructure. The section stated that the judiciary's internal mechanism to maintain accountability includes an established procedure for receiving complaints through the centralized public grievance redressal and monitoring system, with over 1,600 such complaints received between 2017 and 21. In cases where the allegations are serious, the Parliament can take action and remove a judge by passing a motion of impeachment. Such a motion is considered only after a proper inquiry, during which the judge is given a fair opportunity to present their side of the case. But it is stated people do experience corruption at various levels of the judiciary. Hence, efforts are constantly being made at the state and union levels to build faith and increase transparency in the judicial system. It was like this that the report carried in that chapter of class 8th social sciences book.
Go by this broadly because we have no other
Yes.
avenue to find out what it is. Accepting all this, I would still think that, as I was saying, one of the reasons that seems to have weighed is corruption in other walks of life, corruption among other institutions is not referred to. There's no doubt that there is corruption in every walk of life. No wing of the state is free from this taint. But then again, I think that X is guilty of some misdemeanor does not mean that if Y is guilty, he should not, finger should not be pointed at him. I mean, I can't appreciate. It is true that there is corruption everywhere, and maybe even more in the other wings. Granted that, in my view, there are two other very cardinal reasons why the judiciary stands on a different footing. The judiciary ensures, or is explained, that's one of its functions. That's one of its functions, to ensure that all of us, all institutions and people, conform to the law and the constitution. They lay down standards of rectitude and behavior. Their own standards has to be even more impeccable than of any other individual or institution. All power is trust. Judicial power is no less. Judges are trustees. The fiduciary conduct Justice Cardoso laid down, even for an ordinary trustee, is very high. Not the morals of the marketplace is the expression that Cardoso used. For an ordinary trustee, then what to talk of a trust, a constitutional trust, so noble and so lofty? It has to be absolutely beyond reproach. And therefore, even comparing corruption in the other walks of life, or wings of government and the judiciary, I think is inappropriate. The judiciary stands on a pedestal, and that pedestal demands that the standards it maintains for itself is much, much higher any other wing, institution or individual. Therefore, coming back to the order, the court overreacted. In my humble view, this was not called for at all. And we must also not forget that the court has said repeatedly over a period of time in different cases that the shoulders of the court are broad enough to shrug off iniquities. Many times it has done that and won the esteem of all right-thinking people. There have been instances where it has been oversensitive, which I'm afraid is neither correct nor desired. Would this case fall in that category? I believe it would. I don't think. And one other thing that the reason that everyone talks of is that impressionable minds of Standard 8 should not be told all this. That again does not appeal to my reasoning and understanding. I may be wrong, but I don't share it. The more important thing is who is to lay down content of a book. I think it's for the educationists and the government ultimately, because these are policy decisions. Court is not the institution. It is neither the expertise nor the wherewithal to prescribe you and I or any of us to study or read. The court's domain is only when it is called upon. And the even frightening thing is that this is on its own motion, suo moto, not even in a case that is filed. And what is the net result of this? I ask myself, is this not a case of the judiciary violating fundamental rights? When you ban a book, you interfere with the right to freedom of speech and expression. The Constitution, no doubt, permits such interference. It only says that the state is not prevented from making a law imposing reasonable restrictions. The bottom line, therefore, is any reasonable restrictions, which may even at times amount to prohibition, that is well settled, can be done only by a law, not by executive guidelines or orders, and by the same standard, not by judicial fiat. This also, in one sense, violates the principle of separation of powers, violates fundamental right. End of it is all that, the end of it is that when a law imposes what you claim to be unreasonable restrictions, it is the judiciary that we all approach. The court decides the reasonableness of the restrictions and the validity of a law. Those restrictions or prohibitions are imposed by the judiciary itself. To whom do you and I go? As the Bible says, when lost salt has lost its savor, wherewith can it be salted?
Yes.
This is the thought that comes uppermost to your mind.
How do you see the way out now?
And quite curiously, if I may say this, in this case, everyone seems to be hearing the same drummer
Yes.
and singing the same tune. The executive, I'm no party man of any color, but the executive normally, does not always take a correct stand on legal matters. In this case, seems to have simply given in. I don't know whether, purely as a matter of law, whether they should have the way out. You can always close the case.
Because by shutting down or by curbing a reference to it in class 8 textbook, that's one thing. But on record and which has been recalled is, say, a remark by a division bench of Justice Kajju and Gyan Sudha Mishra that was a number of
2010.
years back in 2010 in a matter before the Supreme Court titled Raza Khan versus UP Central Waqf Board, a decision of November 2010 in para 16. It was said that some judges have their kith and kin practicing in the same court, and within a few years of starting practice, the sons or relations of the judges become multimillionaires, have huge bank, luxurious cars, and huge houses, and are enjoying a luxurious life. This was a decision of 26th November 2010, reported by SCC in 2011, Volume 2, page 741. I would also draw your attention to the remark of Justice Bharucha and later on by Mr. K.K. Venugopal, the then Attorney General of India, who before the Supreme Court stated that he had the names of 9 judges of the Supreme Court, saying there is corruption in the higher judiciary. 7 of them said so immediately after their retirement, and Mr. K.K. Venugopal brought out that he had extracts from all of them. The point I am trying to make is that while a reference to this, like in the instant case, may be felt that is not needed that class 8 students discuss this. But nevertheless, the mouths of a common citizen cannot be shut down. And as you have said, that this is not a myth, it's a reality. So something needs to be done about, and for that, this needs to be discussed, talked about. And one of the questions is that that would be foremost in the mind, that constitutional morality and judicial probity, do they have a space in our system or not? I would need your concluding remarks on that.
Of course, they have space in our system. They should have. If, God forbid, they have no space in our system, the system would not be worth anything. And I don't think we would need to have a system like that. As you said, these books, whether they should be told to class 8 or not, may be debatable. It is not of such a proportion for the court to. The side effect of it is perhaps none of us would have known about this book and its contents in the usual course. Students may have read it, it may have been taught in the classroom, there may have been some passing remarks about it. But today, what we have achieved by this bad order, I think I would not be wrong in saying, is that we have given absolute publicity to this. Most of us would never have known about this book. Now we all know. Even if we don't know the full contents, we know this exists.
It makes reference.
It makes reference to that, and it will be talked about. And as you said, when a people talk about it, I think nothing can be done. No contempt power can stifle the people.
So matter would continue to be in the melting pot, and hopefully some solution, recipe would emerge.
Solution or dissolution. Because why I'm saying this is, we all know Mr. Shanti Bhushan swore to an affidavit. If I'm not wrong about the numbers, is that 8 out of the 16 chief justices were corrupt. The matter went on for years and years. And every time the matter is posted Mr. Shanti Bhushan will tell the court, ask the court to take it up. He'll be proved wrong, sent him to jail, saying he would happily go. Mr. Shanti Bhushan is now in the other world. So in that sense, as I said, resolved or dissolved sometimes. It was a very unhappy occasion for us even to speak about this, but at the same time, it is unavoidable. And we only hope, what shall we say, that wisdom and statesmanship prevail and that we don't, this interferes with all constitutional values that we hold dear and of which the court is the ultimate guardian. So it is keeping all that in view. Everyone would have to approach the problem and try to see that nothing doesn't get out of hand. Thank you. Thank you.
Thank you.